Okay, we're going to go ahead and get started at general session here at the VSI conference. Just a couple notes real quick. There are some pages in the back that Megan has set it for you. You don't have to do it right now, but during your leisurely time, please sign those forms in the back. It gives you credit for your hours that you are going to be attending things here at the conference. So again, they'll be located in the back throughout the day. So please make sure that you sign those forms. This general session is going to be sponsored by Abilis Solutions Corporation. Mr. John Taylor, who is with them. If I could have him stand, please. Mr. Taylor, right up front here. Thank you so much. Appreciate everything you do. Thank you, sir. Before we move on to our first speaker, me and John talked, and I'd like for everybody to stand. We're going to say pledge allegiance to the flag real quick. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. You can be seated. Our first speaker this afternoon is going to speak to us on ethics law as it relates to sheriffs. Our guest speaker is Mr. Chris Piper, Executive Director of the Virginia Conflict of Interest and Ethics Advisory Council. Nearly all of Chris's career has been spent in the area of ethics. In 2003, after successfully managing a trade association's federal PAC, he took over as campaign finance manager for the Virginia State Board of Elections, where he oversaw the administration of Virginia's Campaign Finance Disclosure Act. Chris joined international law firm Skadden Arps in 2008 as a political compliance consultant, where he advised the firm clients on how to comply with lobbying, conflicts of interest, and campaign finance compliance in all 50 states, Washington, D.C., Puerto Rico, and the federal government. He rejoined the Virginia State Board of Elections in 2011 as manager of election services, where he oversaw campaign finance, voter registration, and ballot access process before beginning at council in August 2014. Mr. Piper is a long-distance runner with several marathons under his belt, and he's going to be competing in a 50-miler in October. But he's most proud of his two children, 13-year-old Danny and 10-year-old Hannah. Mr. Piper, thank you so much.
Thank you. Appreciate it.
Thank you.
50 miles, I don't even drive that. John says he doesn't even drive 50 miles. Thank you all for allowing me to come here to speak. I think if you've been paying attention to the news, it's kind of funny. The reason I'm here is because we had in Virginia a conviction of a former governor. And just this morning, the Supreme Court is hearing that case. So pretty ironic that I would be here today to speak to you all. But I appreciate that introduction. I'm going to speak to you specifically about how the Conflict of Interest Act, as it's been amended over the last couple of years, applies specifically to you and to your offices. The majority of what I'm going to talk about today applies only to the sheriffs in 9 out of 10 cases. As sheriff, as an elected constitutional officer, is required to file a statement of economic interest. How many of you all have already filed one of those? Few. Good. All right, so if you file one of those, this definitely applies to you. You have to file one of those before you can get on the ballot, and then you have to continue to file them after you've been elected. Now, as far as deputies and the staff of the office is concerned, as local employees of the locality, you fall under some of these laws. Like, for instance, you can't take a bribe. Pretty good information to have. But when it comes to gift laws and gift restrictions and such like that, you're in pretty good shape. You don't have to worry about some of that other stuff. But the sheriffs and those of you filing the Statement of Economic Interest, you really do have to be paying attention to these specific gift restrictions. However, your locality may have determined that your chief deputies or such are required to file these Statement of Economic Interest. So if that's the case, then they would, these laws, these gift laws apply to you, and some of the things I'm going to talk about. I'll try and distinguish before you in each case what applies to those of you who file a Statement of Economic Interest versus the rest of your staff. But first, what I'm going to do is talk about the council itself. The council was created in 2014, modified in 2015, and finally it got up and running last fall. There's 9 members. Three are appointed by the Speaker of the House, 3 are by the Senate Committee on Rules, and 3 are gubernatorial appointments. Of those, 4 are legislators, 2 from each party and 2 from each house. Then we have 2 retired or former judges of record in the Court of Virginia. And then among the gubernatorial appointees, there's 1 who represents, is a former or current executive branch official, and 1 is from the Virginia Municipal League, and 1 is from the Virginia Association of Counties. And that's important because in those 2 are representing your concerns at the local level. And you're served very ably by Walter Irwin and Sharon Pandak. But anybody who's been filling out these statement of economic interest for a long time will tell you that it's a frustrating process because I used to work at the State Board of Elections. I used to oversee how got on the ballot. So if you tried to get on the ballot in 2011, that was my job. So you get this form, and there's a whole lot of information that's required on that form, and a lot of questions, because some of it you don't want to fill out, because it's a lot of personal information, and sometimes you don't want, do I need to give that information? But if you called your general registrar, they'd say, oh, I can't help you with that, call the State Board of Elections. If you call the State Board of Elections, we say, well, we can help you with that, call the Secretary of the Commonwealth's office. You call the Secretary of the Commonwealth's office, they say, oh, we can't help you with that, we're not attorneys, Attorney General won't let us speak to it. That's the end of the line. You had nobody there to assist you. Now, you might have a county or city attorney that would help you, or a Commonwealth attorney that might help you, but again, the problem was, now you've got 133 different people, or maybe even 266 different people, reviewing this big, complex law and coming up with different interpretations of what it means. So the council was created to eliminate that bureaucracy, and what they've done is the council becomes a singular place where any one of you who's employed by the locality, the sheriff's office, or what have you, if you have questions about complying with the Conflict of Interest Act and completing the Statement of Economic Interest, you can contact council. There's 2 things that can happen. We can give you informal guidance or we can give you formal guidance. Either way, when you receive that guidance, you are protected. And what does that mean? It means if you call us up today and you say, hey, I'm not sure if I can use my office's account to send my kid to college. Is that okay? It's not, by the way. But if you called us and we gave you a response saying, no, that's not okay, well, then you're protected. Now, let's say something a little bit more practical. In fact, I'm going to use a direct example. There's the Virginia Sheriff's Association PAC. Just yesterday, the council met and considered a formal opinion about a PAC. And if a PAC, let's say, for example, let's say the Virginia Sheriff's Association PAC is having a fundraiser for candidate X. So you decide to fly a couple of sheriffs out to the fundraiser in Richmond to support candidate X for governor. Now, the PAC pays for that. The PAC pays for that, and you get it. The question is, have you accepted an illegal gift? Well, the council yesterday looked at that question and determined that that would not be considered an illegal gift. And so as long as you follow that guidance that's been provided, then even if a judge were to say, no, that's illegal, the law says very clearly that you follow the guidance provided by the Virginia Conflict of Interest and Ethics Advisory Council, and therefore you cannot be prosecuted. Pretty cool, huh? So, number 1 reason that the council exists is to provide guidance, to provide you information on how to comply with the law. And the best part is that when you get that guidance, as long as you fully disclose the facts, and as long as you actually do what we told you to do, you are not going to be prosecuted for following our instructions, okay? On top of that, any conversations you have with the council, when you contact the council, all of it is protected by the Freedom of Information Act. So what does that mean? It means that you can't call us up, you can call us up, and the next day it's not going to appear in the paper because we cannot tell the press or anybody in the public who we spoke with or what we spoke about, okay? So, for example, there was a kerfuffle back in January involving a question that came into us, and the press was all over us. What did you tell this person? What did you tell this person? So we can't tell you. And we kept to that, and we didn't say about it because that's what's in the law. So you can feel comfortable contacting the Conflict of Interest Council with your questions and know that we're not going to tell your buddies or anybody at all. So that's the number one thing, most important thing I think we do. I think the number two thing that we do that's so important is with those questions, the council is required annually on December to submit a report to the General Assembly and to the governor, making recommendations and changes to the law. And why is that important? Well, this law is big, it's complex, and it is filled with lots and lots of little troubling spots, if you will. But not only that, but I don't know if you've followed legislation, but sometimes it's drafted really quickly and there's little mistakes, it leaves a comma out here or there. Back in the day, that wouldn't really get fixed. Now the council can get together and say, hey, we want this to be fixed, and this doesn't make sense, and it's really making it impossible for people to do their jobs and serve the public properly. In that case, they can provide for recommendations in legislation. So, for example, in December, the council voted on and passed 8 pieces of legislation that they thought would improve the law. Some of it was just purely technical amendments, but some of them were really substantive. And just yesterday, the council met, and the council discussed this whole issue of widely attended event, which I'll get into in a minute. And they decided not to act on anything. They decided that we need to put that in the report and recommended the General Assembly that they fix the issue that seems to be a very big loophole, and they want it to get closed up. So that's one of the things, one of the purposes of the council. And I bring that up because if you don't ask us questions, if you're going to your buddy or you're going to your friend or you go to your city attorney or county attorney, they're great resources. But if you go to them and you don't come to us, we don't have the knowledge of what issues are out there. So if there's something that you're having a question about and you're not quite sure how to handle it, if you don't call us, well, then we're not aware there's a problem to begin with. Maybe there's an issue in the law that needs to be addressed by the General Assembly. That's something, or it could be something as simple that the council can fix. So anyway, another good reason to contact the council when you have questions concerning that. All right, so that's me selling council to you. I hope you buy my pitch. But now we're going to talk about actual the law and how it actually applies to you. So generally speaking, the Conflict of Interest Act is a broad prohibition, if you will, on what you can't do. What's not allowed when you may have a personal interest in a transaction. All right, so for sheriffs, you're not spending a lot of time voting on stuff. You're not sitting in the Board of Supervisors meeting voting on things. Your main thing is signing off probably on contracts for your office. So we're going to talk mostly about prohibited conduct in a contract rather than a transaction. And it's really quite interesting. We understand in Virginia that you had a life before you were sheriff, you'll have a life after you're sheriff. We understand that maybe your sheriff's salary isn't everything it should be, and maybe you have some other projects out there, real estate or what have you, that may be affected in your job. So while the Conflict of Interest Act is a broad prohibition on what you can or cannot do, it's also littered with exceptions to that rule, understanding that you have a life beyond your public service, and also you have to be able to do your job. So let's talk about prohibited conduct and personal interest. What is prohibited conduct? Well, first of all, I'll be very, very blunt. I said it earlier. You can't take a bribe. Is that confusing? All right. You can't transfer or trade your knowledge or your ability to get things done for people for money. You can't use your office for gain. How about that? That's another way of putting it. You can't use your office to get people that you're related to hired. okay? Except in certain situations. I'm not going to go into all of those because we could be here all day. But you cannot take anything for your own personal gain. And this is really where, big E and little e come into conflict. I talk about little e the law. That's ethics, This is what the law says. You can and cannot do it. Then you have big E. And big E is, would your mama want to know you did it? And that's what we ask a lot. Sometimes it may not be covered in the law, but that doesn't mean it's okay. All right? So you have to also do some gut checks on a regular basis. When I worked in campaign finance, I tell you, anybody run a campaigner for your sheriff's office? Trust me, be glad you live in Virginia when you're filling out those forms, because I filled out those forms in a lot of different states. In Virginia, it's not that hard. It's not that big a deal. But there are not a lot of rules governing what you can and can't do with that campaign finance, those funds. So I got a lot of calls and people say, can I do this? I said, well, yeah, you can, but would you want to see that on the front page of the paper? And so that's a question you have to ask yourself when it comes to conflict of interest and ethics. If it smells funny, it's probably going to smell funny. If it smells funny to you, it's probably going to smell funny to a lot of people. So keep that in mind. But we'll talk to you all day about what the law actually says. All right, so you don't use your office for personal gain. You cannot, if somebody invites you to speak as the sheriff and to talk about being sheriff and what it's like to be sheriff, or maybe what it's like to be a deputy, and you're attending that function in your official role as sheriff or deputy or what have you. In that case, you can't accept payment for that. Okay? Yes, you accept a token of appreciation, which would be a plaque or something of that nature. But if somebody's saying, hey, I'm going to give you $500 if you'll come and speak about what it's like being sheriff of Westmoreland County, the first county that came to my mind. I'm not picking on you guys. But if you can't accept like a $500 check for that, okay? Because you're already being paid to be sheriff. So there's that. So that's generally prohibited conduct. Don't do anything stupid. Now, when it comes to personal interest, we talk about personal interest in a contract. Well, what does it mean to have personal interest in something? Well, personal interest is a financial benefit or liability accruing to you or to a member of your immediate family. Who's your immediate family? It's not who you think it is. It's your spouse or any person who resides with you and you claim as a dependent. So that could be your mother-in-law who lives with you and you're claiming on taxes as a dependent, okay? It could be your minor children. It could be your adult children who need to get the heck out, right? But that's your immediate family. If your children live in Texas, they're not your immediate family, okay? Because they don't reside with you. They could be a dependent, but they don't reside with you. All right, so let's talk about what is personal interest for you or a member of your immediate family. It's a little bit more complicated than prohibited conduct. It's ownership in a business if the ownership interest exceeds 3% of the total equity of the business. Annual income that exceeds or reasonably anticipated to exceed $5,000. And then I can go into a little bit more detail, but don't want to bore you with that. Basically, if you own a business and you own more than 3% of the equity, or you have 3% liability in that business, or you're getting salary or some sort of financial compensation in excess of $5,000. In that case, you have a personal interest. I think the best way to explain this that would probably relate mostly to you guys is, let's say you own a property, real estate. And in that real estate, you have more than a $5,000 liability, or you have more than 3% interest in the equity of that real estate. Then you now have a personal interest by law, okay? Let's say before you were sheriff, you owned a Quickie Mart, okay? And in the Quickie Mart, you still own it. You may not be operating because you're sheriff now, but you still own pieces of it. Or maybe your family owns it and you've got a 25% share of that. Well, guess what? You have a personal interest in that Quickie Mart, okay? Now, how's that going to affect you in personal interest in a contract? Well, you cannot have personal interest in a contract with your agency other than contract of employment. So you're employed by that agency. You cannot have a personal interest in a contract with your agency, which is the sheriff's office in this case, other than your contract of employment. How would that relate to the Quickie Mart? Probably not much, unless, let's say, the Quickie Mart wants to get into a contract with your sheriff's office. Well, in that case, you have to remove yourself from the decision entirely, which I think if you're sheriff, that's probably going to be kind of hard to do. But I think more importantly, I think probably more relatable, let's say you own a bulletproof vest company, okay? And you just also happen to be sheriff. Well, guess what? Entering into a contract with your bulletproof vest company is a bad thing, okay? That's a personal interest in a contract with your sheriff's office, with your bulletproof vest company, okay? So that said, that's the broad prohibition. Guess what? There's a whole lot of exceptions to that rule. I like to make the joke that the General Assembly in the Conflict of Interest usually writes about 2 lines of what is not allowed at all, and 50 about what is allowed to accept that 2 lines. So, in other words, you could own a bulletproof vest company. You might want, as your bulletproof vest company, to be the bulletproof vest company for the sheriff's office. And you could probably actually do that as long as it's a sealed bid, and you have no relationship between the people putting together the bid for the bulletproof vest contract with the sheriff's office, and you can't see which company you're reviewing. So it's a blind bid or blind decision-making contest, okay? So there are some exceptions to that rule. But here's the thing. Here's what I will reiterate a couple of times from now, from here on out. This law applies generally when reading it. But in each situation, it's a very, very, very specific, fact-specific situation. So I want to make sure I'm clear. If the sheriff from Westmoreland County calls us up and says, hey, I got a question, and this is the situation, and we give a response, that response applies to the sheriff of Westmoreland County. It is not going to apply to the sheriff of Tazewell County. Why is that? Because the sheriff of Tazewell County has different financial interests, has different immediate family, has different contracts, specifications. There's a whole lot of things that come into play with each question that we ask. So I encourage you to understand that just because your buddy in County A said it was okay, you should still call us anyway and get your own opinion, okay? So that covers our personal interest in contract. Now, I gave a very broad description and very, very broad hypotheticals. I don't want anybody to freak out. There's a million and different ways that you could be accepted out of some of these prohibitions. So just understand that there is this general prohibition of your personal interest in a contract. So if you have outside financial interests that may come into play with your office, then I want you to be sure to give us a call so that we can talk about it. All right, now what I'm going to talk about right now is gifts. And here's the part where we split between what is those who file a statement of economic interest and those who file or don't file a statement of economic interest. So if you file a statement of economic interest, you need to listen very intently from here on out, because it's the gifts thing is the one that's going to get you in trouble. Number one. Number two, for everybody, just like I said before, you can take a gift in exchange for your knowledge or benefit. It is a prohibited ban on gifts if it's seeking to influence you on how to do your job. So you might not file a statement of economic interest, but if the owner of the Bulletproof Vest Company comes up and says, you know what, I'm gonna re-shingle your roof for you as long as I know I'm going to get that contract. You say, all right, I'll take that, and I'll make sure you get that contract. Guess what? Doesn't matter whether you file a statement of economic interest or not, you just accepted an illegal gift because it was meant to influence you. Okay, so everybody understands that, right? All right. Now, speaking to those who file a statement of economic interest, you do have restrictions on certain gifts, and specifically, you have a restriction on gifts over $100. But here's the thing. It only applies if the giver is a lobbyist and a registered lobbyist in Virginia. So John can't give you no gifts over $100. But there's exceptions to that even. Number one. Number two, you can't accept gifts, and this is the one that's going to apply to you more often than lobbyists, okay? You can't accept gifts of $100 or more from any person, business, or organization who is seeking to become party to or is already party to a contract with your agency. So I'll go back to the Bulletproof Vest guys. If they're trying to get your business, if they're trying to sell you their bulletproof vest, and you go to dinner with them and they pay for a $100 steak, you're in violation of the law, okay? You can't accept a gift over $100. Now, if it's a $99.99 steak, man, chow down. You're good, okay? And that's aggregated over the course of a year. So you can accept a $50 steak. You just can't accept another $50 in gifts from them. Does that all make sense? Okay, so if they've already got a contract, not just seeking a contract, but if they've already got a contract with you, you can't accept it. Now, like I said, you can accept up to the $99.99. In fact, I think it's in excess of $100. So you can accept $100. You just can't accept any more than that. Now, what is a gift? This is where it gets funny. See this? I don't know, some of you might not be able to see this, but this is the definition of gift. Okay? I have 2 pages of what is not a gift. All right? But that's how lawyers work, right? No offense to any lawyers in the house. Okay, so a gift is basically anything that has value. Okay, if you can put a value on it, it's a gift. That's really quite simple. To make it clear to things that are specific to you, travel, lodgings and meals, tickets to events, and anything provided in payment in advance. So what's not a gift? Well, if you get a ticket to a Redskins game and you don't go to the Redskins game, that's not a gift. You didn't accept it. Other things, like if you get a scholarship, or if your kid, who's your immediate family member, if your immediate family member, your son gets a scholarship, an academic scholarship to William & Mary, that's cool. You can take that. Anything related to your campaign, so if you were running for sheriff, if they're giving you $500 for your campaign, that's not a gift. That's a campaign finance contribution, right? If you're a featured speaker and they provide you food and beverages, and they waive your attendance fee or the registration fee. So if any of you are here and are here for free because the Virginia Sheriff's Association, which is a registered lobbyist principal, paid for it, not the institute, I'm talking about the association. But if they paid for it, your attendance fee or whatever, because you're here speaking, that's not a gift. It's not reportable. You don't have to worry about it. Okay? All right. If you get an inheritance, these little things are not gifts. And let's talk about what is exempted from this $100 gift cap. Well, there's 2 things, and I'll go over the first one. And this one's the most important to you. If somebody offers to pay for your travel, so let's say the Bulletproof Company wants you to go to the National Bulletproof Association meeting in Orlando, okay? And they are paying for you, they want you to speak there because you've been very successful with their product. And they just want you to come up and give a speech about how awesome their product is. So they offer to fly you down to Orlando, cover your hotel, and you just speak for 20 minutes, and then you're on your own, get a free lunch, whatever. In that case, the travel and the cost of the plane and everything and the attendance fees, well, the attendance fee wouldn't count, but the travel, the cost of the travel, that would be a gift from a contractor in excess of $100, which would be illegal, right? Well, in that case, you can go to our website. On our website, there's a travel waiver request form. And that, you fill it out, it takes all of about 2-3 minutes, and you say, I've been asked to speak at this conference for one of my contractors, and is that okay for me to accept a gift in excess of $100? And what we would do is we'd look at it, we'd take a look, and we'd say, you know what, that makes sense. You're waived, the gift restriction, the gift cap of $100 is waived, okay? So just remember, a travel waiver is required for any travel that is paid for by a lobbyist, or a contractor that's in excess of $100. It's very rare that that's going to happen in the sheriff's office, but understand that it is required that you request a waiver from us in those circumstances. When's the other time you can accept a gift over $100? This has been debated quite a bit at the state level. It's called a widely attended event. A widely attended event is an event where there's 25 or more persons invited or expected to attend, and they all share a common interest. And yesterday, council debated what the heck a widely attended event was, even though, it's in the law. But yeah, if you are invited to a Redskins game, let's say, and you were to, and the cost of the ticket was more than $100, then you can accept that if it's coming from a contractor or a lobbyist principal, okay? Because you're all there, there's more than 25 people, you all share a common interest in the Redskins, whether you like them or don't, okay? The other time you can accept it is if your lobbyist is a personal friend. I think John's a personal friend to just about everybody in here, am I right? Yeah, absolutely. But John's also a red lobbyist. So if you invite John to your wedding, the question is if he wanted to get you a sterling silver, champagne bowl, or I don't know, it's late in the day, I'm tired. But if he wanted to get you something a gift for $100, you could probably accept that because you're inviting John because he's your personal friend. But there's circumstances that we'd have to look into. But there may be situations, where you have a personal friend who had a contract in your office. In that case, it may be possible that you can accept gifts from them in excess of $100. If that were to happen, where you have a personal friend who's a contractor, give us a call. We'll help you work through that. All right. So the last couple of things we'll talk about is about reporting a gift. You don't have to disclose any gifts that are $50 or less. You do have to disclose any gifts if they aggregate, so the combination of gifts from a single source that exceeds $50, okay? So let's say CR gives me $45 gift, and that's it for the entire year. I'll never have to disclose that. Nobody has to say anything, okay? Now, let's say John gave me dinner today. He's going to pay for a $45 dinner. And then 3 months from now, he invites me out and he buys me, and I'm like fancy, right? So I go to Starbucks and I get the $6 venti or whatever it's called. So now it's now my total gifts from John is $51. So now I got to list both the $45 dinner and that nice little $6 cup of coffee he got me. Okay? Does everybody understand how you handle those? So that's really what it comes down to when it comes to reporting gifts. Now, current law says that gifts of $20 or less don't count toward the cap, but you still have to disclose them. So John, in this example, could give me 5 $15 gifts, or how about 20 $15 gifts? That's all acceptable. I've gone over $100, no big deal, because every single gift is under 20, okay? Now the governor has a law in front of him, legislation in front of him that he hasn't signed yet, and we're waiting to find out if he will, that would exempt all gifts under $20. So I encourage you to sign up for our mailing list and take a look and see when that bill comes by. Speaking of which, if you sign up for our mailing list, just go to our website, which is ethics.dls.virginia.gov, and its mailing list is right there on the bottom. So we talked about gifts. That's pretty much the grand overview. The last thing I'll talk about real quick is how to file a statement of economic interest. For sheriffs who are required to file the statement of, you're all required if you're a sheriff. Starting with the reporting deadline of June 15th, beginning May 1st, which is Sunday, you may begin filing your disclosure. And in the past, I think you've always filed with the clerk of the governing body. That is over. You now file with the council. Okay? And you should be notified. If you haven't been notified, then maybe talk to me or maybe contact us at the council after this because we're going to have you set up to file electronically. And it's going to be really easy. You're not going to have to fill out all this paperwork. And once you do it the time, guess what will happen? Next time you file, all your information will transfer over. So if nothing's changed, you can quickly go through and it'll take you about 30 seconds to file your report going forward. This first time is going to take a little bit because we got to get you set up in the system. Then you fill it out and then you submit. But once it's submitted, you have electronic documentation that you submitted it. It makes life a whole lot easier. You don't have to go down to the clerk's office, and it's there for there in our system for everybody to see. So in that case, that pretty much covers that. The one last thing I'll tell you is beginning with this filing deadline, if you don't file by 5 p.m. on June 15th, it's automatic $250 penalty, okay? Now, there's exemptions to that. For example, if you're in the hospital, you have family members in the hospital, or death in the family or something of that nature, then we'll work with you to waive that penalty. But it would behoove you, because you're filing electronically with the council for the first time, is to go ahead next week, when you get into the office, start preparing the report. You'll have all the information from us. If you haven't heard from us, please get in touch with us as soon as possible. We're working closely with the Compensation Board and Robin DeSocio over there, so you probably all are familiar with her and that office. If you haven't heard from us or you're having trouble getting in touch with us, which shouldn't be a problem, but you can contact them because we're working very closely with them to ensure that all constitutional officers are brought up to speed on the new process. In the interim, there's I will also say that we've worked very closely with John. He has been a great advocate for you guys as far as making sure that the conflict of interest and things that you all do on a regular basis are being handled, and the questions are getting to us. So I think you got a great leader here in John, and I appreciate his assistance helping us understand the kind of issues that you all are facing. Because we've talked to you. Some of you may have talked to Rebecca, who's our staff attorney. But our goal is that if you ask us a question, that we want to make sure we give you a very solid, reasoned, and thorough response. So it sometimes takes us a couple of days, but we do respond letting you know we're working on it. But we encourage you to contact us and talk with us about the issues facing you. And even if you're just not sure about it, just any question you have about conflict of interest or ethics or gifts or anything like that, please do not hesitate to contact us. And with that, I think I have I think I ran out of time, but I don't know. If anybody has some individual questions for me, I don't know. I'll be out here. I'm not in any rush to go back to the office, I swear. Don't tell my bosses I said that. But no, I'll be right out here. I'll be happy to talk to you and help guide you with any answers that you need.